Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hello, I'm Angela Princewill.
And I'm Sherine Abdi.
And our topic for you today is child support. So under the law, every parent has an obligation to support their child to the extent that that parent is able to based on their means. And this support is generally for an unmarried child that's a minor. And either, if they're not a minor, then they're either enrolled in a full-time program of education, or if they're unable to be self-supporting because of illness, disability, or other cause. So essentially, for the most part, child support really is just a payment from one party to the other. Oftentimes we hear people talk about supporting the child in other ways. Like I know, Sherine, you've had clients that have maybe bought diapers, bought foods for the child. Like, do you have any concerns with that?
Well, interesting. I actually don't really particularly like it. If parties can avoid doing that, that would be helpful. And the reason I say that is because sometimes it's hard to quantify how much is actually being spent because child support is regulated by the guidelines. There's a specified amount that's required for your income to be paid. And, you know, for example, if you're sending a $500 e-transfer, I mean, actually that's probably a little more easier, but if you're maybe giving somebody cash payments, or, you know, you went and you bought those diapers, but you can't find those receipts and things like that. It's harder. It's much more difficult to quantify how much you've actually paid and give you a credit for the amount that you should have been paying.
Yeah, that's something that I know some clients struggle with, which is sort of what is my child support payment being used for, right? So some people are of the opinion that if my child needs XYZ, clothes and all of that, that I can buy that for my child and not have to pay child support. I mean, if the other party agrees, there's times where it might be appropriate if other arrangements are being made for the child and the child's being appropriately cared for. But more often than not, I would tell you in 90% of the cases, it's really not worth it. Like
it's also not appropriate because sometimes if you don't have an agreement, nothing stops that other person from going back to say, now you owe me X, Y, and Z in spouse and child support, which we'll go over as well. But essentially, like the support that's being paid for the child will go towards, you know, the care and the cost of raising that child. And
they need a room to sleep in. It goes towards that, you know. And I know some people have a problem with that, and they say, well, you know, he or she went and got a bigger home, and now I'm sort of subsidizing their child support. And I understand your pain. I feel it if you're the payer and maybe you can't afford to do that. But you have to remember that if this were in front of a judge, if it's better accommodation for the child, better neighborhood for the child, the judges are going to look at it from that child's perspective. And frankly, child support isn't much of a discussion these days. Like with the guidelines, it just is.
I find that, I think that's also common. I think it's hard for some people to wrap their head around the fact that you got to pay child support. There's, except for very limited circumstances, which we'll talk about, where you can actually reduce the sum that you're paying. But ultimately, it's a very clear issue. It's very black and white, as Angela and I like to say it. So there's really no point in disputing it unless the other party agrees. You know, there are circumstances where it's not uncommon that you guys will come to your other arrangements. But ultimately, you know, I think another concern is like where the money's being spent. It's, you know, I had a client recently say, well, you know what? She's not spending it on X, Y, Z. Can't I just make sure she buys, or can she prove that she's buying, you know, the child what she needs? And I'm like, no. The reality is no one's going to enforce such a heavy burden to show that you're actually spending, you know, the child support on food for the child. I mean, if we're talking about circumstances where the other party is maybe using it for substance abuse and the child not being looked after, again, like maybe there's some merit there, but overall, no. You can't dictate where they're spending the funds.
Exactly. And I know another thing that bothers people a lot is, well, fine, I have to pay, but I've heard people say, well, I'm only going to pay until my child is 16, and then I'm going to give the money to my child.
Yeah,
right?
Or 18, very common.
Yes, some people think after 18 it's over. And it's not, and to be fair to the payors that are thinking that, I know a lot of it is not just rooted in this idea that they don't want to pay. There's concerns about how the other parent is actually spending the money. Remember, some of these people were partners already and understand each other's spending habits. And they might see that they might understand the weaknesses of one person and things like that. But on the other hand, there's people that also firmly believe that after 18, the child should go fend for themselves. And if they were still in a marriage, that's probably what would have happened. But unfortunately, when you're separated now, I don't know if that doesn't apply anymore. Even if your partner was on board with you saying, well, we're just going to provide for these children until they're 18 and then they're on their own because we want to teach them how to face the world and be self-sufficient. That was fine then. If you guys are still on board on the same thing now, great. But if the spouse disagrees after separation, then you're just going to have to pay child support. So long as that child, again, as I said, if the child is still independent, right? Usually they're attending school or there's other cause that makes them unable to withdraw from parental charge. So how is child support calculated?
So child support is calculated it's actually already predetermined.
Yes.
And to determine the basic monthly amounts, we use the federal child support guidelines. And this is...
Or the provincial
child support guidelines. Yep. And ultimately, this is already a predetermined amount based on the average cost of raising a child, depending on your income. So
and your province.
The province, and it's taking into consideration the basic necessities and the cost of living and things like that in the province, and essentially the child support guidelines.
I think you're even overcomplicating it. Honestly, for all they need to know is there's a guideline amount. You can find it by either finding the child support table, the child support guidelines. It's a table. It's just really has on that table. Just find your income, find the amount of child support you need to pay. The government has factored in all of the things Sherine was saying into that number. Or you go online, if you want to find it yourself, you can even just Google child support table lookup, and it would pull up sort of a box or whatever, pull up a page for you, the government page where you could just type in your income, select your province, number of children, it'll spit out the amount that you need to pay. So that's great where it's just a child, or it's a parenting arrangement where one person is just paying child support to the other, and that's simple enough. But let's touch on how parenting schedules sort of affect the amount of child support.
Yeah, so that's actually a funny thing. A lot of people don't know that your parenting arrangement can easily affect your child support obligations. So the simplest way is if you're the primary care parent, you would be receiving the full table amount of child support dependent on your income. If you have at least 40% of the parenting time in your parenting schedule with the child, then you're actually paying the set-off amount, which is the difference between both your incomes.
I'm sure I want to be careful there when we just put it in absolute terms, because you know that with law, everything is never absolute, right?
At least 40%.
So if you have that 40%, what it entitles you to is a conversation about it. So the courts, when you have that 40% threshold, then now the courts can look at changing your support, and but they will still look at the means, needs, and the other circumstances of the child, right?
Yeah. Granted, it's not automatic. I think that's the easiest way to put it. But if you're honestly at 40% or even at 50%, the reality is, for the most part, you would be paying the difference between your incomes, absent one of those circumstances regarding the means, needs, and circumstances of even the standard of living between the different households and things like that.
Yeah. Okay. So, you've talked about sort of having the child for 40% of the time, but for most, actually, before I even jump to that 40% discussion, so the shared parenting, you can now what kind of child support would you be looking at in that scenario? I guess because a lot of people, why I say this is a lot of people come to us saying we have the child 50-50, and so I don't have to pay child support. That's a very big misconception.
Oh, I see what you mean. Yeah, honestly, it's one that I think a lot of people have. Unfortunately, if you're the higher income earner, you're going to be paying the other party the difference between your incomes. So it doesn't mean that there's no support obligation.
Yeah.
So if there's an income discrepancy, if your incomes are similar, then yeah, nobody's going to be paying the other party any child support because your incomes are similar. But let's say the other party has a higher income. Unfortunately, you're going to be the one providing the other party with support, especially if there's a big disparity in incomes.
I think the easiest way I tell people to do this is if you figure out how much, mom's child support obligation is based on mom's income, what's dad's obligation based on his income, and then the difference, is the set off amount. And the set off amount is what gets paid. Now, a word of caution there, because if you're both looking at applying for the child
tax benefits.
Yeah, the child tax benefits. You want to be careful to make it clear that father is paying mother $1,000 in child support and mother is paying dad $500 in child support, even though we know the net result of that is a $500 set off.
Interesting point, actually. And because only one party can claim the dependent credit as well. So that's also an addition. So you want to make sure that you're factoring in for those credits and those benefits. And if you do have a shared parenting arrangement, then ultimately you should be sharing those credits. I mean, sometimes with your incomes, you may not qualify for some of those credits, but parties can come to their own arrangements.
Yeah. So, and besides shared parenting, there's also other arrangements like, if it's I've had clients where there's 3 kids, 2 children are in one home and one is in another home. Again, kind of use the same formula, figure out what one parent, if one parent has 2 children with them, figure out what the other party needs to pay based on 2 children, and then you would know what you get, and then do the same for what you need to pay to the other parent because they have 1 child in their care majority of the time. So explaining this, I hope it doesn't sound more complicated than it needs to be, because it's really not, but it's just we just want to debunk some myths around people thinking, well, she has some of the kids, I have some of the kids, so I don't have to pay child support, or we have the children equal number of times, so I don't have to pay anything. And the number of times that, I have had people resist giving equal parenting because they think they might not get child support. It's interesting. And I'm like, it doesn't really matter. You might still get child support depending on your incomes. If he or she earns way more than you would probably still get a lot of child support there. Also, remember that child support and spousal support kind of work hand in hand. So if you're insistent on having a shared arrangement so that you don't have to pay child support, well, remember that all of a sudden now you have the ability to pay spousal support. And even in shared scenarios, some people, when you're in, and if you've listened to if you haven't listened to our podcast, you should listen to the one about spousal support, where we sort of talk about whether you should be in the low, mid, or high ranges, right? If there's a shared arrangement, I strongly believe there's an argument that could be made for spousal support to be paid on the higher end, right? Because you want the children, there's now that focus on children having the same standard of living in both homes. So anyway, so that's sort of our quick notes on how child support is calculated. Another thing to remember, the benefits we talked about, it is not a factor in calculating child support. The number of times people have told me, like, she gets, $1,200 in child tax benefits, and then they want to deduct that from the $2,000 that they were supposed to pay in child support. It doesn't work that way.
Especially if you don't have a shared parenting arrangement, you have no basis to ask the other party to deduct, I guess, what they receive, or have an amount, entitlement to
It
that
shouldn't
amount they're
even come
receiving.
into the equation. My opinion
You'd be
is it really
surprised.
shouldn't. Yes, and
You'd
if
be
it does,
surprised how many times it gets brought up. Well, she's receiving the child tax benefit. She doesn't need X amount of dollars in child support. Unfortunately, it doesn't work that way.
it doesn't. It's
So,
not. If you
please
have
be
a shared
mindful.
parenting arrangement, get your child tax benefits directly from CRA. If CRA is going to split it between the both of you, then they do. And I know there's times where people have agreed to one person getting the child tax benefits because that person has a lower income
And they're eligible for it.
It works out better for.
And sometimes they put it in an RESP account, and they have different arrangements that they come to.
I mean, I'm just going to just say word of caution there. We're not asking you to do it or not to do it. Do what's best for your family, but you just want to be careful there.
Just from a CRA perspective.
Yes. So okay, go ahead.
I think we were talking about how to actually calculate that 40% in general, which I think is an interesting topic. And I think the most common is it is really a numbers game.
Mm-hmm.
So either you can do the days approach by counting the different days that the other party has parenting time, or you could do it by the hours. The hours approach is more favored by the courts according to case law. In saying that, it's not just a one universal way of calculating it. The courts have also made that very clear. But the best way to do it is what the court considers care and control. So, for example, if you're the parent dropping off a child at daycare or school, you would count the time from that overnight or any period that you've had the child, but your timer would essentially stop at the time that you drop them off if the other party is the one responsible for picking up the child and having parenting time after school. And so they would kind of get a portion of time
would
allocated to
that still apply
school.
though, Sherine? If the other parent, for example, is just picking up and maybe is not even on the list of like people the daycare can call, like, you know what I mean? Because when I'm thinking
So that's why the
control,
court, yes.
I'm thinking if the other side is the party that the daycare will call if the child is sick, then they still have care and control up until the moment the other party picks up after daycare. So you see
there is an argument, and that's where the court would consider, okay, well, the reality is who's the closer party. If the other party is working, in Timbuktu and has to drive 2 hours to the daycare. I mean, that's a very unreasonable parenting arrangement, but it's not uncommon that there can be, jobs that take at least an hour to travel to. So the court's going to consider who's going to be there first. But ultimately, if you're the parent that's going to be picking up and not just having a small period of time with the child, but actually, having that overnight, then that time should be allocated towards you. Of course, there's an argument with everything in law. So, but just to kind of a basis to understanding, that 40% threshold. An easier way to do it, yes, if you're doing the days approach, you could also do that in a more simplest to complex, unless you guys are doing such, often transitions. So that's where I would say the hours approach, while it may seem very numbers, yes, tedious and very number focused, it's actually more accurate.
Okay. And over what period of time do you base these hours calculations?
So there's also a discrepancy between whether or not we should be using the entire regular schedule or include the summer and holiday schedule. To be honest, I would prefer just doing the regular schedule because that is the primary time.
Yeah, because I know under the act it says
365
that over
days.
the course of a year.
Yep.
Right? Yes. So I mean, if we want to be completely accurate, then we should look at the regular schedule and then count the summers and holidays and all of that. So yeah, it could get really interesting when there's a dispute over, the 40% versus or less threshold.
When in doubt, I would consult a lawyer just because sometimes it can be a very rigid calculation that you'd have to do and very annoying. So, and sometimes, you're not understanding that. And we could do multiple factors. So just to really get the determination. So if you're at that 38, percent, and you need that 1% to get you to not paying, hopefully reducing the child support, then that might be an option for you.
Okay. So you touched on summer, and that kind of reminded me of summer child support issues. And I find that it comes up in a couple of contexts that I can think of the top of my head now. One is some people are thinking, well, for some people that have, say, a shared parenting arrangement, during the summer, they don't feel like they should have to pay child support. And then there is also children in post-secondary schools that return home during the summer. What's your position on that?
So are you making reference to not share during the year, but only during the summer? Yeah, it comes very often, and unfortunately, no. While we understand, like, maybe the majority of the time you're sharing, the child is still being accustomed to their home, and it's just a summer schedule. We're talking about 2 months here.
I mean, except of
but
course,
to be honest, unless they agree, because I actually...
No, I'm even thinking if it not even agreeing, like, what if the summer schedule just takes you over the top of that 40% that you're looking for, then that's a thing. But if it doesn't, and the other party doesn't agree, then there's really no justification for you not paying the full table amount in the summer, even if you have the child 50% of the time in the summer. Right.
I mean, it's not uncommon to have a provision in your agreement to say that the summer months, even if you have over 40%, would not constitute as a basis to review support. So
Absolutely.
something worth noting. But for the summer months, for children in post-secondary expenses, I shouldn't really call them children; they're more like semi-adults
In post-secondary school.
in post-secondary school. Technically, that's where I would say there's an argument there, and it depends. Are they coming home for the summer? Are they, having a summer job? Or are they really truly just sitting at home? And if they're dependent, honestly, then I would still seek the partial amount of child support. And there is that's calculation that would actually just factor in the summer months just for that portion of the summer.
Yeah, I mean, you could just pay the table amount for just those 4 months of summer. I find that those calculations are usually more helpful when you want to spread out that summer child support over the course of the year. If not, if you guys agree. And I mean, I don't want this to be interpreted as us saying all post-secondary students are only eligible for child support in the summer. That's incorrect.
Yeah.
The only time that I think it's appropriate to only pay summer child support for children in post-secondary schools is if the child's in residence and you're contributing to their the cost for them remaining in residence outside of the home. Yeah. But if they're not in residence, then you would still need to pay child support the regular way all year through. Or if you're not contributing to it, I guess too might be an option. Okay, so now that I guess that what are our thoughts on sort of child support being paid to a child directly? Did we talk about that yet?
Yes. So it's not an uncommon request. Unfortunately, no, I don't agree. And especially when we're talking about the pedigree of a child who's truly a child. I'm sorry, but if they're 10, they're still a child. Even when they're 14, 15, 16, they shouldn't have the child support should go to the parent, because the parent is actually being able to assess what funds are being actually used for the necessities that the child needs. It's not like the child's going to go out and buy, their own toiletries. I mean, we'd like to think our kids are all that responsible, but honestly, it's very inappropriate, in my opinion. And again, It depends on the nature. There are circumstances where people have agreed, and where it may be appropriate. Overall, I don't believe it. I don't believe that's appropriate.
Yeah, I'm with you on that one. Okay, so let's talk about these Section 7 expenses. So because and by Section 7 expenses, I mean special and extraordinary expenses, because we just talked about post-secondary schools. So let's kind of talk about that. I mean, what are even special and extraordinary expenses, right? We talk about that all the time, and most times we just say Section 7 expenses. And if you're wondering why we do that, it's because it's under Section 7 of the child support guidelines. So, I mean, what are some ideas of...
So the most common Section 7 expenses are daycare, or medical expenses outside the coverage that you guys have. Anything such as, tutoring, private tutoring, or things like that are the most common, honestly.
Yeah, the post-secondary expenses.
Yes.
Yeah.
And what's important to note is these are actually in addition to child support.
Yes.
They're not, you can't just say, you know what, why doesn't she just use the child support?
Or deduct it,
use
or
the child
deduct
support.
it from
Yes.
the child support.
Doesn't work that way. These are in addition to your obligation to pay support. And these are paid proportionate to your incomes. So, if you earn similar incomes, then it's going to be very clear that you each are going to pay equal shares.
Absolutely. Another thing that falls under these Section 7 expenses are extraordinary expenses for extracurricular activities.
Yeah.
So let's be clear, it has to be an extraordinary expense for extracurricular activities. Sometimes people interpret that to just mean extracurricular activities. So for the most part, it might be appropriate to pay additional amounts if your child's attending, I don't know, whatever activities they're involved in. But just be mindful, if the cost is minimal, especially after tax cost is minimal, then the courts may expect that you use your child support amount. But if it's extraordinary, like I heard hockey's expensive, most rep sports, whether it's rep dance or soccer or whatever, are pretty expensive. So that would be an extraordinary expense. And I know a lot of times, parents, I've had clients that are concerned about paying for these Section 7 expenses because they think it's expensive. And it is, right? Like, you're separated now, you don't have sort of that joint income anymore, and it could be difficult. And I hear you, but I found that a lot of times the judges would approve some Section 7 expenses. And I know it would cause hardship to you because, after all, child support is not tax deductible. You just pay child support and, you're just left with the rest of your income. But if your income is really low, or if you have other obligations and you're struggling with that Section 7 expense, even though in the opinion of other people it might look minimal, then it's a conversation that's worth having, especially if it's beyond what the children had while you were married, right?
Exactly.
So it's the whole idea to try and at least maintain some kind of quality of life close to what they had before you separated. But life happens, things change. So should we jump into undue hardship under these circumstances?
I think so.
Okay, so what is undue hardship?
So undue hardship is essentially where, unfortunately, due to circumstances that will actually go into factors that you can determine, that you're actually unable to pay the child support amount and potentially even the Section 7 expenses. And you can bring a claim for undue hardship, asking and requesting that the court consider your application to reduce the child support amount.
Yes. So that's well explained, Sherine. That's really what it was. Just remember that it says undue hardship, not just hardship. I tell people there's no way that paying child support is not some sort of hardship on most people, but it just has to be undue. And under the guidelines, there's various factors that the legislature has listed that would be factors in or circumstances that would be looked at as causing undue hardship. So part of that is if you have an reasonably high level of debt that you incurred to support your spouse and the children prior to separation or to any living. So I have seen cases where undue hardship claims have been brought because after the date of separation, just, life's difficult and things like that, and that party has incurred an unreasonably large amount of debt. It usually doesn't apply. The courts would not, would not care. One of the cases we're going to actually talk to you later, when we're talking about retroactive child support, had to deal with an unusually high amount of debt, but the courts did not factor that in because it was incurred after the date of separation. If you have a unusually high expenses in relation to exercising access, right? So I'm thinking flying in from Thunder Bay from time to time to see the child.
To Saskatchewan, like those parenting arrangements, having to, pay such a significant cost just to exercise your parenting time.
Yeah. So I have tried with a client in Barrie and the other in Durham region. The judges weren't very pleased with the argument. We did get something, but not as much as I would have wanted. I just thought we should get a lot more given the distance. But that's just to give you an idea that if you're probably closer than Barrie, then maybe that high cost of gas and stuff like that may not qualify for undue hardship.
Yeah, if you live 45 minutes away, an hour away, no.
And yeah, if you have an obligation to support another, any other person. So let's say you have, if it's a separation agreement and an order for child support for someone else or for spousal support, that's something that the courts can consider when looking at your undue hardship claim.
Sometimes that's the most common one. So, having other support obligations. And the courts will consider that, especially if you have multiple children, because there is support paid to the first child approach and that whole circumstance as to what is appropriate in that circumstance.
So none of these factors are determinative. They're just things that the courts would look at. You have to bear in mind before you bring this kind of claim to think about what kind of standard of living do you have compared to the other party, right? So even if you're suffering an undue hardship actually to yourself, but but you still have a higher standard of living in your home versus the recipient's home, the courts are not going to care. They're not going to care that you're paying more than half of your income for support to other, to children from maybe a previous relationship, to a first spouse. The courts wouldn't care because as far as they're concerned, on your 50% hardship claim, if you have a higher standard of living, then that's it's a non-starter.
It's still better than the other party. Again, the priority is to focus on the child's obligation to receive that support. But it's interesting. I think overall, what you're trying to say, it's a high threshold.
It is. Exactly. Yeah. It is a high threshold. It's not something to try very lightly. A lot of cases involving this are for the most part unsuccessful. So once you figured out what child support you have to pay, you've thought about whether undue hardship applies, but we've not even talked about what income do we even use in calculating the child support, right? If you're a regular employee, then we're just looking at line 150, or it looks like CRA is calling it 1500 these days. And that's it, because it usually is a reflection of your T4 income anyway.
Yeah, and by regular employee, we're not saying that you employ yourself and you're paying yourself from your corporation. We're talking about those who truly don't have, the ability to actually have a business and are not self-employed, essentially.
Yes. So another thing that comes up often as well when we're talking about incomes is people say, for people that maybe their incomes have maybe risen over the last 3 years, because there's a provision in the guideline where the courts can look at your pattern of income in setting the income for child support, people just take it for granted that it's automatically just a 3-year average. It's not. There must be a reason, just without even having to paraphrase it, it just clearly states that if the court is of the opinion that in determining your income, under Section 16 would not be the fairest way, then the court may look at your income over 3 years to determine an amount that's fair and reasonable in light of any pattern of income, fluctuation in income, or receipt of non-recurring amount during those years. Exactly. So if your income is just maybe going up because your employment income's rising, you're getting these promotions, you can't really just use
the average. That's not really appropriate. It's really meant for, let's say, you're a seasonal worker, maybe 1 year.
Or commissioned workers, for example.
And, that year you did great. Unfortunately, next year, we're talking about significant decreases and increases between incomes, like a true fluctuation, not a fluctuation based on actual performance and things like that. Commission income is a very common one, seasonal work. And honestly, unemployment can also be, but then we'll talk about imputed income. I
would have an argument.
If you're laid off for a portion, for half a year.
I might have a concern with that, Sherine, because let's say this is 2021 and a client 3 years ago was not employed. I don't really care though to do
and
an
that's
average.
So that wouldn't be appropriate.
Yeah, so I don't want people thinking, well, I was unemployed for 1 year. You have to remember that for most people, we're going to talk about the annual review of child support. So if all of it is going to factor in at some point. So we're going to get there. But first, another way of determining your income. If you're a shareholder, director, or officer of a corporation, then we're going to be looking at your pre-corporate tax income. And you need to understand that there could be adjustments made to your pre-corporate tax incomes to claw back some of the expenses. So, I mean, obviously we know for CRA reasons, if you could pay management fees and benefits to different parties and all that, and they may not necessarily be arm's length parties and things like that. While you're doing great for tax planning purposes, for child support purposes, that income might be clawed back, rather than looking at what your net income is. You might be looking at paying child support on your pre-corporate tax income. Obviously, there's ways around that. Just looking and making sure
the expenses are reasonable and things like that.
Yes, exactly.
I think that's a very common one. Is the people intend to rely on their net income, no.
Yeah, and it's disappointing to find out that it's not, and it's upsetting, right? So if you believe that the expenses were appropriate, they were paid to arm's length parties, they're necessary for you to generate the revenue and keep the business running properly, then absolutely, that's.
But if you're writing off your rent for where you're actually living, your vehicle expenses, things like that, they would be clawed back. Meals and entertainment, very common one, again within reason, but it's just a fair note that your income, just because it's on CRA, is not going to be the income that we're going to be using.
Yes, absolutely. So now, what of where your income is too low? So let's talk about this all important subject of imputing incomes.
My favorite.
Yeah.
So imputing income is essentially where you believe a party's underemployed or intentionally underemployed or has the ability to be self-sufficient and is not. But I want to preface this by saying each parent has an obligation to support themselves and support their children. And of course, if you're not, this is where imputing income to the other party becomes relevant. So let's say, for example, one party is intentionally underemployed, and earning maybe $20,000, but has the capacity to earn maybe $70,000. That is where imputing income comes into place. We would be looking at the relevant factors, such as your ability to work, your experience, your skills.
Why are you not working? If it could be medical reasons, then we want to understand what those medical reasons are, right?
And whether they're enough for you, because not every medical reason, and to be honest, I think that's a very common one, is, I have, not to displace that these are important issues, but there are still jobs that are, you're able to actually, participate in and generate
just because
income.
of that obligation to support your child, right? So, yeah.
Yep. And sometimes if you're receiving, those kinds of incomes from the government and assistance, some of them can be grossed up for taxes. So that's also important to note.
Yeah, I know that for imputing income as well, you could look at spouses that, so if you're exempt from paying federal or provincial taxes, the courts would impute income to you, so that, as Sherine said, it could be grossed up in that context. If you have property that you're not reasonably utilizing to generate income for yourself, the courts can also impute income to you, because, hey, it's one thing to be, your property also needs to be generating revenue so that you could provide a better quality of life, standard of living for your child. If you unreasonably deduct expenses from your income, which we kind of talked about earlier with,
or if you're hiding income, I think that's a common one as well.
Yes, that's
if you're
a
hiding
big one.
income, I think that's the most common concern that I get is, he gets cash jobs, and we can prove that. Sometimes it's difficult, of course, because So with cash, we know that it's, goes largely unrecorded unless, we can see large amounts being deposited and a tracing. Or sometimes if you have the benefit, for longer marriages, it's very common that they're privy to that information,
Yes.
and they have like receipt books and things that we could produce as evidence to show that, there is additional income sources that are not being disclosed. So credibility is an issue.
Yeah, that's a good one. Also, if you're getting majority of your income as capital from capital gains, then income could be imputed to you to gross up that income, right? Yeah, and what else? I'm sure there's other circumstances.
Investment income, rental income are all income for support purposes.
Exactly.
Regardless of what you believe and even what you claim as rental income versus what you net, there's also, again, what you report to CRA is going to be different from our purposes.
Yeah. I find it interesting that under Section 19, the Act actually makes it very clear that the reasonableness of an expense or deduction is not governed solely by whether the deduction is permitted under the Income Tax Act. So like we said earlier, it doesn't matter that CRA allows you to do that. It's not, it may not be allowed for child support purposes. So, for those that are somewhat concerned about, patterns of incomes, and some saying, well, I make less in some years versus other years. And if we're not averaging out your income, well, does that mean you're just like left there? Take heart, because child support is changed annually. So the worst that there's two ways you can approach these, child support payments. My favorite and easiest one is to pay based on the previous year's income tax returns, whatever your income is. So let me just say the previous year's income, because as we know, we might not go by what's on your notice of assessment. So in 2021, child support would be based on your income in 2020. So if your income in 2020 was less than what it is in 2021, if you're the recipient, you're receiving less because their 2020 income was lower. But come 2022, when they're paying income based on 2021 income, it doesn't matter if 2022 income is lower, you're getting the higher amount. So it kind of, it sounds convoluted. So, it adjusts yearly.
So if you overpaid, it gets adjusted. If you've underpaid, it gets adjusted.
But another way people like, that's the most accurate way, it just requires a little bit of math, is to pay to set support based on your estimated income for that year, or even pay based on, even if you're paying based on the previous year's income, but there's an understanding that at the end of the year, you're going to calculate how much child support you paid and how much you ought to pay. And if you've overpaid, then you would deduct it from support payments going forward. And if you've underpaid, then you might have to pay it over a period of time or pay it back as a lump sum. So that way, it's either way, your actual income is what your child support is going to be based on, either in real time or from you getting the benefit of paying based on the prior year's income.
Because I think that's sometimes a concern, especially if maybe in one year you did a lot of overtime.
Yes.
And then received a bonus, and the next year, unfortunately, maybe the company didn't do so well, and you didn't get that bonus, and you didn't have a lot of overtime shifts. So you would get that adjustment. So don't worry, it will be credited. Of course, unless you're do other provisions and other have another agreement there, but ultimately child support gets adjusted annually based on your income.
And you're supposed, so every year you're supposed to disclose your incomes. Usually people ask why. So you mean forever she needs to see my income? And unfortunately the answer is yes. And it goes both ways if there are special and extraordinary expenses. So remember the Section 7 expenses we talked about earlier? Well, you need to see her income. She needs to see your income, because without that, how do you calculate your proportionate share of expenses, right?
Yeah, so just like child support gets reviewed annually, so will those Section 7 expenses.
So in 1 year, so if in 1 year you made a lot and now you're paying 70%, well, the next year it may readjust so that you only have to pay 50% or even less, depending on how things have gone. And again, if that's too much for you, that you can't afford to pay based on the prior year's income, it's possible to pay on the current income, but understand that there will be adjustments done later to make sure that you're paying based on your correct income.
Yeah.
So sort of the documents that you need to exchange every year to figure out, child support and Section 7 expenses are, your personal income tax returns, notice of assessment. And I know sometimes people ask me, and I'm sure, Sherine, that's happened to you as well, why do they need my income tax return? I already gave her my notice of assessment. Well, I'm going to tell you, for one, and you can add to that, if the income tax return tells us how you're getting your income. So if you have rental income of, I don't know, 50,000, and now because of expenses, it's now minus 80,000, for example.
Yep.
I might not be able to get all those details, see what you deducted and things like that.
Any non-taxable income you can see there, any benefits, credits
Yes.
paid, really anything. Even if you received, for example, if you're paying for your share of daycare and you allow the other party to claim it, you could see what portion depending on how your arrangement is. Some parties have the other party paying half of the amount back to them, credit off child support. But you can get half of that care credit essentially for the daycare cost that you've paid. So you can actually see what that is in your income tax return. Granted, you may be able to see it on the notice of assessment for that particular example, but we need to be able to see the actual expenses and things like, especially if you're self-employed, we can actually see the expenses you've deducted. Mm-hmm. And very detailed sheet of business and activities and statement of income and things like that. So very relevant. Don't think that you don't just get to disclose your income. I think that's a common problem is that people will just say, oh, I already told her my income, it's XYZ. And I'm like, but she needs the disclosure, or, the reality is like, you could sing it until you want, but the disclosure is required.
Yeah, it is. And for those that are earning, incomes of over $150,000, under the guidelines, so the guideline amount kind of caps out at like 150. If your income is greater than 150, then the tables may not apply to you, and the courts would have to look at your conditions, means, and other stuff to figure out an appropriate amount. But we can tell you from experience, the courts usually don't do that. Like your income may be 200,000, and they would want to apply like sort of a straight
I think
amount.
To be honest, I've never really had that. Yeah, never really. Maybe an income over 250.
Yeah, but
but unfortunately, they're not very quick to change the support amount to find it inappropriate based off an income of 150.
Yeah. Okay, so you now know that, you now know what child support is, that if you have a child, you have an obligation to support the child. It will be based off on sort of the parenting arrangements that you have. You have to disclose. That's extremely important. And you know that you have to review. You have to do this on an annual basis, and you kind of have an idea of what your income would be like. And the other thing I want to add there on that note is, we also would like to see security for child support. No?
Yes. So for those that are unaware, it's actually an obligation for you to secure your child support obligations under the law. The most common way is life insurance, to secure a certain amount of the policy to the other spouse the other parent being an irrevocable beneficiary. Sometimes you could designate other people as a beneficiary in trust for the children. It's not uncommon. Either registering a lien on the estate, on their property, or a first charge against their estate is the most common, or designating a certain portion of an RSP to secure that amount. The amount required to be secured is actually factored already in the calculation. We can determine exactly what the amount is required. And every year, of course, it would go down a little bit, but we don't usually adjust it every year. Mm-hmm. But it's important to know that it's not just overpaying the monthly child support. You also have to secure it. And the reason is, in the event that the unfortunate passing of that payer parent, then, the other parent doesn't have to actually sue your estate as a dependent, and actually can just get the insurance proceeds or the life insurance or whatever portion you've set aside throw whatever I mean.
Yeah, absolutely. Okay, so what about, I want to talk about people that have stood in the place of parents to another child, mostly step parents, right? So, the interesting news here is if you're a step parent of a child, you may have an obligation to provide child support to them, right?
Mm-hmm. Even if you're not the step parent, but can be conceived as one. So if you're living together in a common law relationship for a good period of time, that's also considerate to stand in the place of a parent. So the length of your relationship would be a factor. Your relationship with the child, your financial, the ability of how much you financially supported the family and that child specifically, your relationship with that child. I can't even remember any more factors.
I think you really have it all, covered, right? I think the only other factors that the courts would look at is the biological parent. If the biological parent is able to, what's that parent's legal obligation to support the child? So if they have an order to pay child support, are they actually making these payments? And which I know is very shocking for some people, because they would say, well, that's their biological parent. If that person isn't paying consistent child support, why do I have to be on the hook to pay child support? I don't know the answer, except to say that
if you meet one of these factors, unfortunately,
and it's the best interest of the child is what I'm thinking. Actually, it's the best interest of the child is what it
prevails.
Yeah, if you're the more reliable payer, if you provided a certain standard of life for the child and you had a close relationship with the child, and now there's a biological parent who may or may not pay child support, and the child has to suffer, then the courts will make you step in and pay that child support amount. Now, on the bright side, if the other party is paying child support, that could be a factor in whether or not you pay just the guideline amount, or if it's an amount that's different from the guideline amount. Don't worry, it would not be more than the guideline amount. It may be less, because I know when I said different there, it's like it could be interpreted any number of ways. So how do you prevent yourself from this obligation? There's only one way: entering into a marriage contract or a cohabitation agreement. So usually when we do those agreements, we make it very clear that it doesn't matter what you do for the child. It doesn't matter that the fact that the child lived in the home and you provided all of these benefits, financial benefits for the child. None of it is going to put you in the place of a parent, and none of your generosity would be construed as you trying to stand in the place of a parent.
Exactly. That's really the only conceivable way to really prevent such a claim.
Yeah.
Other than the other party agreeing.
Yeah, so we didn't touch on the issue of retroactive child support, but I think we've loaded you with a lot of information, and we'll just leave this by saying that we'll do this at another podcast. I think we've loaded you with a lot of information, and we should probably have another day where we kind of go over what retroactive child support is and things like that.
Enforcement and how to actually enforce child support. So I think, that can be a whole another podcast. I think
let's do that next week. Why not?
Okay.
All right. So until next week, bye for now.
Bye. Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.